Hi, and welcome to iTenif Healthcare Solutions webinar, Using NextGen to Ensure Interoperability and Compliance with the 21st Century CURES Act. My name is Chelsea Grover, and I'm the Marketing Communications Coordinator for iTenif. Before we dive into today's webinar, I'd like to go over the process for today's presentation. First, I'd like to mention that this webinar will be recorded, and that we'll send out copies of the slides and with the recording within the next week. Next, for those of you who aren't familiar with iTenif, I want to share a bit of who we are with you. We specialize specifically in next-gen healthcare, and we're passionate about providing solutions for healthcare provider partners, which in turn help them to improve patient care, enhance the patient experience, and maintain a financially healthy practice. To sum it up, we do everything next-gen. We also have some next-gen add-on productivity solutions, including ChartGuard and Refund Manager. Next, I wanted to mention some upcoming educational webinars that we'll be presenting in the near future. First, on March 17th, we'll be presenting NextGen Document Management 101, how-tos and tips and tricks. And then as soon as NextGen releases their 6.2021.1 update review or version, we will of course be doing our usual favorite features and functionality overview of it. So keep your eyes out for that because we'll be sending that out as soon as we can. Okay, so back to today's webinar on using NextGen to ensure interoperability and compliance with the 24th Century CURES Act. At the end of the presentation, we'll open the floor up to questions from you. We'll answer all the questions at the end, but you can type them in the questions area of the webinar control panel whenever they occur to you. And finally, for audio clarity purposes, everyone's phone will remain muted throughout the entire webinar. If you experience audio issues, please use the chat box to let us know so we can resolve them. And again, questions may be entered in the questions box and answered at the end. So without further delay, I'd like to introduce our presenters for today. Lindsay Lanning is Manager of Client Development, and Carly Hogan is Client Solutions Specialist at iTenif. So Lindsay, the webinar is all yours. Feel free to take it away when you're ready.
Great, thank you, Chelsea, and thank you everyone for joining our webinar today on NextGen and the ONC 21st Century CURES Act. Now, in 2016, under this 21st Century CURES Act, the Department of Health and Human Services, which I'll be referring to as HHS today, announced the creation of this information blocking rule, which generally prohibits interfering with the access, exchange, and use of electronic health information, or EHI. Over the past 5 years, compliance dates for the rules have been consistently moved back. However, sadly, the time is finally here for this information blocking rule to actually be enacted. Complying with the many different parts of this complex rule will require a complete change in the way medical information is shared. And our goal today is to make sure your practice is informed and prepared. So what you can expect us to cover over the next hour, and it will likely be the full hour, is information about the rule, what it requires and prohibits, some of the exceptions to the rule, deadlines for compliance, as well as general and of course NextGen specific compliance strategies for your practice. Again, our goal is to answer your most frequently asked questions and provide you with tangible actions you can take right now, right when you hang up from this call, to avoid information blocking. So we'll go ahead and jump right in. For the past 4 years, you've probably heard terms like CURES Act, information blocking, interoperability rule, and some other related terms tossed around out there in the healthcare industry. Well, these all revolve around the same very important set of laws that were released last year that will literally change the future of the healthcare industry, and it will definitely affect each one of you. So let's start with breaking down the 21st Century CURES Act. So again, it was actually enacted in December 2016, and it included 2 provisions. Promote health information interoperability while also prohibit information blocking. So as a result, the Department of HHS issued 2 final rules in March of last year. First came from ONC, and that was the 21st Century CURES Act, Interoperability, Information Blocking, and the ONC Health IT Certification Program. The second rule that was a part of this came from CMS, and that was called Interoperability and Patient Access Rule. So there are 2 technical final rules at play here that were mandated by this overall CURES Act. Specifically in these rules, they provide a definition of what information blocking is, which it's defined as intentional withholding of patient health information or anything that interferes with access, exchange, or use of EHI. It's also important to note what information blocking is not, and it is not a requirement to proactively make all EHI available through patient portals, APIs, or any other health information technology. It was enacted to address concerns such as lack of interoperability, sharing patient information, reducing healthcare costs, and improving patient safety. And it also gives patients greater control over their data, which if you've been reading the news lately, that is a huge theme going on right now with the new HIPAA right of access requirements as well. And lastly, and most importantly, who does this affect? Well, it affects what are called actors, which are made up of healthcare providers, health IT developers, and health information exchanges. Now, it's important to note that the term healthcare provider, when talking about actors, does not just mean physician here. It covers everyone on this page, from hospitals, I see skilled nursing facilities, ASCs, pharmacists, therapists, labs, and obviously you can see so many more. So think literally any clinician, entity, or facility that provides a healthcare need, this rule affects them. Like I said, we thought macro was big, and now look at what we're dealing with. So what will this mean for you? And will you see penalties enforced if you don't properly comply? So this rule is going to fundamentally change how providers respond to requests from third parties for EHI. Requests may now come from a variety of sources, and your practice can be asked to share information in a specific format. This means your providers or practice are responsible for not information blocking when it comes to data requests, but not only from your patients, but other non-traditional requests, such as from other practices or from hospitals in your area as well. Providers have to educate themselves and implement policies to ensure they're not violating the information blocking rule requirements. So kudos to all of you on here. You're clearly already trying to do this. You're on the right path. And then lastly, for penalties, there's nothing totally defined as of yet, but civil monetary penalties have been proposed for certain violations. But they're not coming. How do I say that? You know, we can expect these to eventually come down the pipeline and affect providers in due time with further rulemaking. But as you can see here, this slide shows some graphics taken straight from ONC's FAQ page and also even from some of NextGen's Health Reform Simplified slides on these specific FAQs. So this shows additional clarification from ONC that more rulemaking must occur before penalties are in place for providers. So specifically, it says enforcement of the information blocking regulations depends upon the individual or entity that's subject of an enforcement action. For health IT developers and health information networks, the HHS Office OIG is currently engaged in rulemaking to establish those enforcement dates. For healthcare providers, HHS must engage in future rulemaking to establish appropriate disincentives as directed by the 21st Century Cures Act. So again, that is straight from an ONC FAQ. They don't have anything right now, but it will be coming in the form of appropriate disincentives in future rulemaking. Now for some deadlines. So the final rule was issued in March of last year, but it wasn't actually published until May of 2020. So there was some confusion surrounding that. And then the compliance deadline was pushed out due to COVID. So here we are, the official deadline is on April 5th, 2021. That is only 4 weeks away. Now, until October 6, 2022, this information blocking rule would only apply to a more narrowly defined category of EHI, such as data elements in the US CDI standard. After October 6, 2022, this rule applies to all EHI. So we'll talk about the differences in the coming slides, but basically we need to be in compliance with this. The kind of application deadline here is April 5th. And then from April 5th, 2021 to October 6th, 2022, you have this more narrow scope of information this applies to. And then after that October 6th deadline, it's all EHI. So what exactly is this US CDI that I mentioned? So it stands for the United States Core Data for Interoperability Standard. This is going to replace the Common Clinical Data Set, or the CCDS definition, officially December 31st, 2022. But US CDI includes the following data classes and data elements. You have provenance, clinical notes, pediatric vital signs, and then of course you have the patient address, email, phone number, things like that. A little bit more detail here with, I think, a really helpful graphic, again, taken directly from ONC sources. This is going over, specifically before October 6, 2022. All of the following categories are considered USCDI. So that's allergies, assessment and plan of treatment, care team members, clinical notes, you've got immunizations, labs, meds, demographics, problems, procedures, smoking status, vital signs, etc. After October 6, 2022, that list expands and also includes things like billing records, payment and claims records, case management records, and really any other record used in whole or in part by a medical group to make decisions about an individual. Now, it's important to clarify that EHI does not include any psychotherapy notes, any information compiled in reasonable anticipation of or used in a civil, criminal, or administrative action or proceeding, and then, of course, de-identified health information. Those are those kind of three buckets, three categories of EHI that would not be included. Okay, so that was a lot of policies and kind of legal jargon thrown at you, which is what we wanted to avoid with this webinar. So let's bring this down to a very real level where we can understand how this applies with some actual examples of information blocking. So example 1, not responding to a data sharing request from 10 days ago because 2 of your MAs are out sick and the rest of your staff is extremely busy due to being temporarily understaffed. I think it's very relatable currently, especially in COVID times with what we're dealing with if someone was exposed. This scenario happens a lot. Example 2, not completing your clinical progress note in a timely fashion for a given encounter. Number 3, a provider charging patients an extra $250 service fee to fulfill an electronic request from the patient surgeon to share recent lab results. And then number 4, declining a data sharing request from another provider or another practice because the provider does not use the same EHR as your practice. So these will all technically be breaking the law. Things are getting serious. I'm sure a lot of you could relate to or admit to at least one of those examples. So this shows how big of a change this will have on regular practice operations and the healthcare industry as a whole. But of course, there's bound to be some exceptions to the rule. There always is with HHS and ONC. So you can see the 8 exception categories here. We're not going to dive into them all for the sake of time, but we will highlight a few scenarios that would fit these exceptions and give you a quick overview of the top 3 we think will impact your practices most often. So the 8 exceptions are preventing harm, privacy, security, infeasibility, and then health IT performance. And then you've got the 3 on the bottom, licensing, costs, and content and manner. Now, I do want to point out the note to the side of the graphic that clarifies if you do not immediately meet one of these exceptions, your actions are not automatically considered information blocking. Instead, the action will be evaluated on a case-by-case basis to determine whether information blocking occurred. So the first of 3 exceptions I think you will come across most often is preventing harm. So this is protecting patients and other persons against unreasonable risks of harm can justify practices that interfere with access, exchange, or use of EHI. So the harm standard here is generally life or physical safety of an individual and must hold a reasonable belief the practice will substantially reduce the risk of harm. So what this means is that it will not be information blocking for a medical group to engage in actions that are reasonable and necessary to prevent harm to a patient or another person, provided certain conditions are met and the practice's actions are no broader than necessary. So, for example, you say you have a patient who has a history of high anxiety, and as their provider, you just received their test result back confirming they have a malignant tumor. Delaying the release of that test result until you could discuss it with the patient in person because you believe they may harm themselves would fall under the preventing harm exception. The next exception is the health IT performance exception. So this recognizes that health IT must be maintained and improved from time to time to perform properly. So this may take health IT temporarily offline to implement performance enhancements, i.e. a planned EHR PM upgrade. So this could mean you have to temporarily restrict a patient's access to their EHI while you install a system upgrade. You just want to make sure that this action is implemented for a period of time no longer than necessary to achieve that maintenance or improvements, and make sure the timeline is well documented. And lastly, the content and manner exception. Of course, I saved the most confusing for last. Okay, so this exception provides clarity and flexibility to medical groups concerning the required content of a medical group's response, aka what EHI you provide, and the manner, aka how you deliver it to them, in which the medical group may fulfill a data request. So think content, what information you release, and then manner, in what format you release it. So here are some examples. If a patient requests XYZ data and they want it via the portal, you would need to send them that data, and you couldn't mail it. You would need to send it through the portal. Unless you don't have a patient portal, then you could claim this exception and work your way through a rubric that's provided for this exception to determine the next feasible way to get this to the patient. So again, another example that's becoming more and more popular are patient requests. They want their data for a new health app they're using on their iPhone to track healthy behaviors. So again, unless you can work your way through this entire rubric that ONC has provided, far too long to include on this slide, but it basically asks questions on alternative options you might have. So unless you can work your way all the way through that rubric without saying, yes, I can deliver it this way, you will need to get the patient the data they want in the form they want it. So this may sound a bit scary, but one thing to point out is that this is only a problem if the patient isn't happy, or the practice, or whoever else is requesting information. If your patient is fine with getting their data via a USB drive instead of the portal, for instance, then you're done. It's when both parties can't agree that'll cause an issue. So really my advice to you is to try and work with your patients and make sure they have what they need and they're satisfied with what and how you provided it. This could also be a big one for hospitals or other practices requesting data in a certain format. Just try and work together, if possible, to find a solution. Otherwise, it's an extensive amount of questions and alternatives you have to work your way through to claim this exception and withhold the data for it not to be information blocking. So the bad news is there's no way around it. We know this can feel extremely intimidating as a final rule in whole, and it really requires an overhaul in the way we think about releasing health information. This is a true culture shock versus just a list of requirements from the government like we're used to. But the good news is we at Attentive want to provide you with as many strategies as possible so your practice can be prepared to comply with this rule. So how can providers and practices prepare for information blocking? Because this rule is a game changer and there's a lot to it. So unfortunately, there's not an easy answer, and practices really will have to put in the effort to understand the rule. However, some strategies you can put into place include creating policies to facilitate timely exchange of EHI, ensure implementation of all tools and resources available from your vendor, update and revise HIPAA policies and BA agreements, develop a specific protocol for invoking exceptions, conduct routine staff training, and verify any state level requirements. Now, with all those suggestions, you might be thinking, okay, great, another generic list from a webinar I can't really do anything with. I get it, but come on, you give me a little more credit than that. We're on year, 5 or 6 now of these webinars. I really try and anticipate what you all are actually looking for. So here are some actual tangible places to start coming off of that kind of more generic list. So start at the top. Designate a leader in your medical group. You need to have a point person for information blocking policy development and for any issues that arise from patient requests for EHI. We're seeing a lot of these duties being put on your chief privacy officer. If you have the bandwidth for a designated person, I could definitely see this being a full-time job once this really gets going. Review and revise existing policies and procedures. Again, complete a thorough review and if necessary, revision of all existing organizational policies and procedures revolving around receiving, processing, and responding to requests for any EHI. Coordinate with your health IT vendor. Work with your EHR. I would assume almost everyone on this call is with NextGen, as well as your patient portal vendors. If you don't have the NextGen portal or the new PXP portal and you are using a different portal, keep them in the loop and start that conversation now. And make sure that you're able to implement some sort of health IT policies that your organization needs from them to support that EHI access. Next, review any fees charged to patients. This is a big one. You want to avoid charging fees to patients requesting access to their EHI through any internet-based method. So that's apps, email, etc. Then ensure that any fees charged for requests via physical media, going back to that paper copy, a flash drive, anything like that, comply with the requirements for reasonable and cost-based fees under HIPAA. This rule is really tightly wound kind of around HIPAA and coincide on a lot of different areas. Evaluate all data use agreements and other agreements that could intersect with information blocking. So think, again, health IT vendors, any sort of local HIEs you might be part of, and maybe you have agreements with other hospitals and any other entities like that with sharing data. And then lastly, we have these two here. One, establish a process to apply exceptions. So truly develop a process, this could be a decision tree even, to review EHI requests from patients and ask the question, should one of the exceptions be applied? ONC will be evaluating information blocking complaints and exception applications on a case-by-case basis, and I keep emphasizing that because this means any group seeking to apply one of the exceptions will need to fully document each case. Documentation in this rule will be extremely important for supporting documentation to relay to ONC or CMS why you picked the exception and how it's justified. And then lastly, but I would arguably say probably most important, is train your staff. Train both administrative and clinical staff regarding information blocking policies and the importance of adhering to these. Groups should also consider regular training exercises that include discussions of actual patient EHI requests and how these were handled. We're seeing a lot of groups implement this truly almost as they do their yearly HIPAA training. Now you've got a yearly information blocking training. I have groups who are having their staff members sign a paper that they went through that training. So then they have that documentation on hand if ONC were to look that everyone should know what this is. And it's important for that training to be, relatable. If you're just throwing legal jargon at them, kind of how we did at the beginning of this, it doesn't actually resonate with these staff members until you really go through a true real life experience. So using actual patient EHI requests is the best way to go about this. Now let's delve even further into some of these strategies. So reviewing and revising all of your policies sounds, really quick and easy, right? I know. But here are some things to keep in mind as you begin this process. So first, you need to define what is a reasonable base for engaging in known practices that may implicate your organization into information blocking. So let's kind of break this down. The information blocking definition states, interferes with access, exchange, or use of EHI knowingly. So what's the knowledge standard? Well, the rule specifies it is just knowing a practice or a certain action is unreasonable. The takeaway being, a practice is only information blocking if you know an interference is unreasonable. Now, I am not saying ignore this whole rule, because when ONC comes knocking at your door, you can't say you're safe because you get to say you had no idea this existed or its requirements. Definitely not. Living under a rock was not one of the 8 exceptions I mentioned, so let me be clear on that. What I am saying is that if you take the time to sit down and brainstorm scenarios that you know could be considered information blocking in your practice, and you commit an act that is not on that list, you could claim you didn't know it was considered that. Again, don't leave something off the list that you know to be information blocking to try and get a free pass. because I don't think ONC is going to go lightly if, let's say one of their FAQs that's clearly published on their website was, for instance, not on your list. So our recommendation is to create this list as soon as possible and treat it as a living document. As more guidance is released, more FAQs are released, or your practice comes across more scenarios of EHI access, add to this and build it up. Again, any sort of training that you can prove you gave your staff on this goes hand in hand with this document, because you then have stock to show we trained on this and we didn't know that it was information blocking. You also may want to consider including all of these topics when you create your policies. So one, it sounds extremely simple, but it goes a long way. State that your organization prohibits information blocking. Start there. Then clarify who's responsible for upholding this. Provide your procedure for reporting potential information blocking practices. Include a procedure for auditing, and include a procedure for attesting to no information blocking. And then create standardized forms for responding to those EHR requests. These can be used when you're receiving, processing, or responding to requests, and specify how access to EHI may be provided. 2 notes here. Any documentation created as part of an EHI request or the application of one of those exceptions I mentioned should be retained for at least 6 years. If you've heard that 6-year mark before, it's because we find it under HIPAA. Again, a lot of similarities here. Note number 2, retain all policy documentation for at least 6 years from the date of its creation or the date when it was last in effect, whichever is later. So bottom line here, you're going to want to keep any and all documentation for a minimum 6 years. If you have a place that you can save it for longer, it never hurts. Now, once the policies are in place, you must train your staff regularly on information blocking. So you may want to start with, what is information blocking? Who handles requests for EHI in your practice? What are the exceptions and how would they apply to your practice? And then to whom do you internally report potential information blocking practices to? I know NextGen has a UGM presentation saved out on the Success community that does a great job of explaining what this rule is and why it's important to start with your staff. But then make it specific to your practice to answer the who, what, and why questions for your internal operations. Next, you'll want to investigate how your practice may participate in information blocking right now. I always say I'm my own worst critic. Well, it's time for each of you to be when analyzing your own practice. So start with these questions. What systems involve requests and/or disclosures of EHI? Think release of information, think patient portal, maybe contracting with third parties. For each system, what practices interfere with access, exchange, and use of EHI? Think any denial of requests to connect to the EHR, intentional delays in providing lab results to patients, potentially unreasonable security practices, or maybe restrictive contract terms. And then for each practice that raises an issue, does it involve EHI? Is it required by law? Does at least one of the 8 exceptions apply? Or are all the exceptions criteria met? Now, when asking those questions, if there were things that came to mind, I want to reiterate that you are likely at risk of violating the information blocking regulations, because this practice likely either meets the elements of information blocking and doesn't meet an exception. So if you are subjected to an information blocking investigation, these practices will be analyzed. Again, I have that case-by-case basis to evaluate the facts and circumstances on which that practice is based on. For healthcare providers specifically, the government must show that the provider knew the practice to be unreasonable. Hence, the list I recommended earlier, like I said, partnered with education and training. If they're reviewing your case and you claim you were unaware XYZ action was information blocking, that holds a lot more weight if you can also show the training and/or education you and your staff reviewed to prove you weren't just ignoring the rule and you were just uninformed. So to remediate these potential risks, you're going to want to modify your practice or that action to bring it within one of those exceptions where possible. Or if you're unable to actually bring it within an exception, then maintain documentation on that specific practice or that action that includes a description of the facts and circumstances, why you engaged in that sort of action or practice, and then why you determined that specific action or practice was reasonable and necessary. Again, I can't say this enough. It is all about documentation here. Other items to consider implementing are included on this checklist. NextGen themselves presented this slide at UGM that provides NextGen-specific functions or features that can best set you up for compliance with information blocking. Again, this is another really good place to start. So ensure your providers and staff understand what a CCDA is and integrate it into your clinical workflow. Ensure that all of your practices, or excuse me, your providers at your practice have direct email addresses registered and are using NextGen Share. Encourage widespread adoption of your patient portal. Consider signing up with any suitable HIE. Sign up for your respective immunization registry in your state. Verify all your interfaces, Rosetta, HL7, etc., and any technical or software elements that are up to date. Ensure your patient access API is installed. You can start to implement routine use of the PHI log template and apply any necessary regulatory software patches. Again, a lot of these kind of checklist items do coincide with, for instance, MIPS reporting under that PI category. If you do report under MIPS, you should have already had the patient access API installed. Your providers are likely already do have a direct email address and are using NextGen Share, as well as encouraging, the adoption of the patient portal for all of those as well. So we are seeing, a nice kind of weave here with all these regulations coming into play. But I do want to be very specific. There is not a general checklist that acts as a magic wand, that if you do all of this, you will be in compliance. The rule never specifies any specific technology. It never mentions an EHR or a portal. So these are just ideas NextGen had to use their system to meet the intent of the rule. But again, it's not exhaustive and it's not a guarantee. We are currently waiting on a white paper for official recommendations from NextGen. They mentioned that in their last Health Reform Simplified webinar. I believe Andy Riedel is working on that currently. So when they do post that white paper, it will be accessible on the dedicated 21st Century Cures Act page in the Success community. There is a wealth of information here, including the letter they actually released in October of 2020. This, again, is really helpful. It could be helpful to download and, dare I say, add it to your CURES Act binder, which could be saved electronically or on paper stored right next to your MIPS audit binder. I think it would be a good idea to group all of your policies together with any other documentation that becomes relevant from NextGen. Like I said, maybe those training certificates, similar to HIPAA, et cetera, things like that. Now, with this act, it does also add ONC certification requirements to both the EHR and portal. As a result, you have the MedFusion PXP portal will be the native portal for that spring 2021 release and the certified portal going forward. And again, this 6.2021.1 will not support the legacy portal. So this graphic shows how you can remain compliant with the upgrade path taken directly from NextGen. I cut off the first half because that had shown previous timeframes with patches and things. We're kind of at this point in our upgrade path or phase. But you can see the screenshot also showcases a few additional compliance dates on here beyond CURES specific. Just never hurts to have those on your radar as well. And here again, you have NextGen's timeline for CURES Act deadlines. So as you can see, the top is for the vendor requirements and the bottom is for providers. So that final deadline to upgrade to a NextGen CURES compliant release and portal is expected to be December 31st, 2022. So I'm not going to talk through this graphic for the sake of time, but if it hasn't been asked already, we will be sending out a copy of these slides. So you will be able to review this information and this graphic specifically in detail for those dates. Now, it's worth pointing out health IT developers have an important role in helping to prevent information blocking, which means NextGen will play an important role in your practice's compliance. So these next few slides are actions that your practice can take right now and must take before April 5th. So I'm going to go ahead and turn it over to Carly to take you through these very NextGen specific actions. So Carly, feel free to take it away.
All right, thank you, Lindsay. So in order to comply with information blocking rules as a NextGen Enterprise client, you'll need to have the Patient Access API configured. So before April 5th, you must confirm or request Patient Access API installation. This slide provides you with step-by-step instructions on how to do just that. So once you reach the steps shown in the screenshot on the right to configure API access, you would just check the box next to the practice that needs access if they don't have it already, and then you'd click update and then validate, and that will add the API for your practice. This slide is showing you how to do the same thing, but it's just doing it from a database perspective using SQL if you prefer that way. If you do not have the Patient Access API installed, you can request it at the link on this slide. You must be on version 5.9.0 or above to install the Patient Access API. Okay, so that's a pretty easy part. Now I want to talk about third-party vendor requests. Remember that patients can request their health information through really any format that they want via the new rule. NextGen will be evaluating third-party apps for API access. So you can send any apps to the email address listed on this slide, and NextGen will evaluate them. By April 5th, NextGen is going to have a single point of contact for all new data access requests to make things a bit simpler. It is your practice's choice to allow a third-party access. And when we say third-party access, we mean that a non-patient could access patient data. But remember, you really can't disallow this unless it falls under one of the 8 information blocking exceptions. NextGen is going to notify third-party vendors requesting access to any US CDI data that is not available. So what does this mean? Well, let's say Dr. Smith's practice is currently on NextGen version 5.9. One of Dr. Smith's patients is using an app on her iPhone called Healthy, and this is just an app we made up to clarify. The patient wants access to her EHI using Healthy, and she requests access to pediatric vital records. You're going to see on an upcoming slide that pediatric vitals are not currently available as US CDI on NextGen versions prior to the upcoming spring 2021 release. So what would happen in this situation? Well, NextGen would notify the Healthy app that this EHI is not available, and this situation would fall under the content and manner exception, which is going to be provided to the patient and the app by NextGen. However, your practice is also going to be responsible for having a process in place to ensure you notify the patient within 10 days of the request that this information is not yet available. Now, this next slide is hitting on a lot of the same things we discussed in the last slide, so I'm not going to read it all off, but it'll be a helpful reference when we send out the slides. And speaking on that last example about the Healthy app in another light, you'll see that some data items like pediatric vitals still need to be built into the core of NextGen. And this is where exceptions come into play. So there is some leniency to gradually make all data available. So what do you as a practice do when a patient reaches out to you with questions regarding an API app? Well, you would simply direct the patient to reach out to the app directly, whether that's through the developer or through the help section of the app. The app would then reach out to NextGen, and NextGen would work with the app to find a solution. Remember that your practice is not in control of the app. So as long as you direct the patient to reach out to the app, this would not reflect negatively on you or punish you for information blocking. This next slide breaks down what data your patients will have access to depending on your NextGen version. NextGen will provide you with a definitive list of US CDI data that will not be available for 2015 certified versions. The 2015 edition CURES update version, aka Spring 2021 release, aka 6.2021.1, will include all US CDI. So the center column on here is showing what is not yet available to the patient, But to be honest, most people are not really looking for this data. You will see there to note it mentions clinical notes are available in base 64. This pretty much means that most third parties can take that and convert it and still be able to read the data. But again, you will definitely want to have a process in place for documenting these requests, as well as a communication plan for how you will respond with what data is not available within 10 days of the request. And then our last column is showing that the 2015 CURES update, again, spring 2021 release, will have everything required that any patient or vendor would be looking for with no exceptions. Now, NextGen already has the perfect place built in to document any PHI requests. And if you don't already use NextGen's PHI log, now is definitely the time to start. The PHI log allows you to track how a record request was made, what format the records were requested in, and when the records were provided. It can be accessed from several places, but the simplest is usually the PHI log link on the patient information bar. When record requests are received, both clinical and front office staff utilize the EHR to view HIPAA documentation and the disclosures of PHI log. Now, I know a lot of you are probably familiar with how to use this already, but in case you are unfamiliar, we'll briefly walk you through how to use this feature. So PHI disclosures can be automatically or manually updated. For example, if NextGen Share is used, a disclosure would be automatically generated. In this instance, we'll show you an example of manually adding a PHI log disclosure to a patient's record. So upon opening up the PHI log, you will see this link, and you would then select Add, and a new disclosure of PHI would open. This example is filled out as though a physician had requested a patient's record, but you can see the options to fill in who has requested the record, how it's provided, and the purpose of disclosure. In the Processed By box, where NextGen Admin is currently filled in, this would always autofill with the user logged into the system to track who released the PHI. Once all information is added and saved, this disclosure would be added to the list shown on the right, which makes for an easy place to track all PHI disclosures for that patient. If you then select the PHI log history, you can produce a document with all PHI disclosure details that's printable. So you probably already knew the PHI log was a helpful tool, but with the information blocking rules in place, you can imagine how helpful it would be to have these records in place if you're ever questioned regarding information blocking. All right, the next topic is a big one. It's been talked about a lot since the information blocking rule was released, and some practices are concerned that meeting this portion of the rule could affect patient safety. So we're talking about lab result requests. To make it clear, there is no option in the NextGen Enterprise system that will prevent a patient authenticated app to access any lab result, signed off or not, or any other data required by the regulations. You cannot introduce a blanket policy that states something along the lines of, our providers review each lab result before providing them to the patient in order to prevent harm. This would be considered information blocking. Yes, you heard that right. Whether a lab result is signed off or not, whether a provider's even looked at it, it can be accessed by a patient who requests it. Now, this next slide is covering the same situation, but we wanted to show you exactly how the ONC responded to this in an FAQ. The ONC said that they understand you don't want your patients to, misinterpret their results or learn about a life-threatening or serious test result without your clinical guidance. However, in their final rule, and later clarified in their commentary on their final rule, they said that generally speaking, this would not be allowed, even if the spirit is to protect that patient. ONC stated that routinely time delaying any broad classes of EHI will be considered information blocking and would not fall under the preventing harm exception. Any decision to delay lab results would need to be based on specific circumstances that made it reasonable and necessary to claim that exception. These would all be looked at on a case-by-case basis. So, bottom line, you absolutely need supporting documentation to explain why you did not release test results in a timely manner. Now, the usual follow-up question we get is, how is timely defined in terms of responding to a request for lab results? Unfortunately, timely in terms of number of days is not specifically defined in the final rule. But something to consider is that the HIPAA right of access law that defines timely as responding to a patient's record requests within 30 days. But honestly, we really don't think that 30 days will be considered reasonable and timely at all for providing lab results. So unfortunately, we just don't have a definitive answer in terms of time frame, besides whatever the ONC decides to constitute as a timely fashion. As we get closer to wrapping up here, I want to provide you with some FAQs from NextGen that will come in handy as the information blocking deadlines approach. So I know we've said this a couple times, but what date do you need everything in place? April 5th. It's 4.5 weeks away. And on that date, you need to have a process in place for how your practice responds when a patient requests their data. And then remember, by that same date, you need to make sure you have your patient access API in place if it's not already. Now, ensure in that policy stating how you respond to patient data requests that you're also including which data is currently not available based on your NextGen version. So thinking back to that 3-paneled table a couple slides ago, you just want to clarify in your policy based on your version what you would not be able to provide to your patients right now. And also be ready to give any patient that policy specifying what's available or not within 10 days of their data request. And then just a reminder that any vendor issue that comes up, so again, say that healthy app that we made up a little bit earlier, reaches out to your practice. You would need to refer them to NextGen. And anything that NextGen cannot provide, NextGen will provide that third party with the appropriate exception. Again, if a patient has an issue with a third-party app, your practice is not the one responsible for fixing that. All you can really do is refer the patient back to the app, and you can get NextGen involved. And then if you need to access the entire information blocking rule, we've also included that link on this slide as well. One last thing that has been a pretty popular question is, when will NextGen Apple integration be available? So NextGen is actually moving its API platform to AWS this coming summer, 2021. And this is going to have the infrastructure needed by Apple for integration. Then we have US CDI that's going to be delivered post-summer 2021. So just thinking about what's coming later in the year. This will include the Apple Health Deliverable development. It's going to include electronic case reporting, which is expanded to FHIR. And it'll have Dorsata, which are new enterprise routes for women's health. And with all those NextGen tips, I'm going to go ahead and pass it back to Lindsay to close us out.
Got it. Thank you, Carly. I'm sure all the practicing these past few days have just put a strain on your poor voice. So thank you for toughing through that. So just some final items here as reminders of what to get started on as soon as you hang up from this call to kind of bring it all together here. So start from the top down. First, install your patient access API or use the steps that Carly went over to validate that your API is installed already. Create a policy of what you know to be information blocking and then list out your version as well immediately. Again, ensure your organization has a plan in place for response and documentation related to your patient requests. This is likely where you would include what US CDI is not yet available based on your current NextGen version. Schedule training for your providers and practice staff as soon as possible. Create that CURES Act binder for supporting documentation, whether it's electronic, whether it's in paper, whatever works for your practice. And then, of course, consult your legal team for any guidance specific to your organization as well. So I know this is a lot of information and a lot of changes happening in what seems to be a very short amount of time, but this new legislation is like nothing we've really ever seen before. It's significantly different and it's going to cause what I think to be a true culture shift and a new way of thinking when it comes to sharing data and overall interoperability. You know, previous efforts that we've seen in this kind of realm around sharing data has been like meaningful use or the actual certified health information technology program. It just basically told providers and health IT vendors to meet specific requirements in the hope that it would then lead to interoperability. But as we've seen, it didn't work out that way. So what we're used to are these lists of check, I met this, I'm in compliance. And this is a whole new structure of law where you're not focused on meeting the letter of the law, rather the spirit of the law. So as our new national coordinator for health IT put it, interoperability is never done. All the things we went over today are only the beginning, and we want to make sure you're all on track to keep pace with this very rapidly changing environment, because if there's one thing we can be sure of, it's that this trend toward greater data fluidity and transparency is definitely not going away. So we have reached the end here. If you are looking for next steps, or if you're just uncertain where your practice currently stands, ITENIP can help. We can assess your current readiness, we can provide recommendations, and we can help with those policies or procedures. We actually do have a healthcare industry advisory offering. It's similar to one of our MIPS packages if you've ever worked with either Carly or myself in the past on those. It offers things like individual updates on pertinent regulatory and legislative changes that would impact your practice and NextGen, and then of course tailored recommendations specific to your practice based on those changes and any regulatory deadlines. And a lot more too, but please continue to sign up for our webinars and visit our website. And of course, you are always free to test drive our products. And then here's my contact information as well as Carly's. If you do have any outstanding questions and have to jump off due to time, feel free to email us. Otherwise, we are going to open up the floor to questions now. So thank you everyone for joining us today. I'm going to go ahead and turn over to Chelsea to go ahead and facilitate those questions.
Wow, that was a lot of information you guys just threw at us. Okay, so we do have a number of questions that have come in so far, but if you have more, we're just going to go through them in the order that we received them, so feel free to keep sending them. First question, doesn't data share care quality automatically respond to data share requests from another facility? Cindy, do you want to answer that?
Yes, that first of all, if you're using care quality, it absolutely does, provided the facility is participating and provided that the system that the facility has is one of the ones that care quality is using. So the answer to that is a wide-based yes, but it's not 100%.
Great, thanks, Cindy. Next question. What constitutes timely fashion when referencing the completion of the medical note?
I can go ahead and take this one. I was waiting for that to come in, so whoever asked that. This is a really hard one because I'm going to give you an answer that you don't like. Unfortunately, there is no specified time period for timely access anywhere in the rule. They really kept things broad. There's nothing here, and I think we mentioned that, and you probably asked that before we got to the labs portion of it when we kind of talked about the rule has no specified timeframes. They just use this broad term of timely. When we put it in the context of HIPAA, right? HIPAA's right of access is 30 days. They just proposed to bring that down to 10 days and ended up not going through. When we look at if releasing a lab result, for instance, in 30 days, that's really not reasonable. So timely is something that you also probably would want to define at your practice level and justify why that time period is considered timely in your mind. So, or why you guys pick that time period. So sadly, no set definition. I can't give you 7 days, 10 days, etc. I would just say to define that in your practice policies with supporting documentation and a supporting statement with how you got to that conclusion.
Great, thank you, Lindsay. Next question. What changes would need to be made to a business associates agreement?
I can grab that one too. So I know we mentioned one of the main things was to review your BAAs. So if you think about it, I mean, your business associate agreements are in place to make sure you're in compliance with HIPAA, right? And they're all about because they would have access to that EHI. You want to review those agreements and make sure, for instance, that your BAAs are about sharing access. Maybe there's some contract terms in there. I know NextGen had to go through some of theirs that were too restrictive or too, limiting the sharing of data than it should have been. So I would just review any of your BAAs and make sure, again, those agreements are focused around sharing data, which is what exactly this rule is focused on, to make sure nothing sticks out as information blocking through those agreements at all, but it's still, obviously protecting the patient's privacy and in compliance with HIPAA.
Great, thank you. Next one, is an ophthalmology practice required to sign up for an immunization registry?
I can grab that one too. So, and I know we gave you that list of things to do or ideas of how to, be as interoperable as possible. And this is where I say it's not one size fits all. Obviously, as an ophthalmology practice, you're likely not giving out any immunizations. With that, you don't have to do that. It's not a required step. Like how I said we were used to, with meaningful use, you have to do X, Y, Z to be in compliance. This isn't the case. So I would not think you need to do that at all, only if it's applicable. Think of the spirit of the law, right? You want to be as interoperable as possible. So there are no hard requirements so that you wouldn't have to join an immunization registry. But if you are actually, administering vaccines, you would want to because you want to be as interoperable as possible. I hope that makes sense.
Okay, great. Next question. When you enable care quality, do you have to document consent for the retrieval of information from the patient? Cindy, do you want to take that?
Yeah, okay, that varies. I have just that varies by state, by compliance officer, So I don't have an answer to that. I've had some that say interpret it one way. I've had others that interpret it another. That you have to get consent. You can put it on your, basically where it comes down to is that some of the compliance officers feel you can just put it on your standard consent, and that applies here with care quality. Others believe that you have to give them an opt-in and opt-out, which is why in my previous answer is if you're participating in care quality. So I would say you really need to talk to your compliance officers about that. And if you don't have one, I would err on the side of caution. It seems that most of them are coming down to the fact that you do have to have a consent form specific for care quality.
Thanks, Cindy. Next question. How does this apply to a practice that does not have an EMR?
I can grab that one. So again, I did mention in the presentation that the rule, not only does it not specify timely, but it also doesn't specify any sort of technology. And EMR is not specified in the rule as needing to be required to meet or be in compliance with this. So, practices still have the ability to be in compliance with this. It just is going to look a lot different, and I think, be a lot more difficult for them. But it is still possible to meet this without an EMR. I think it's just getting creative for how to share that data.
Okay, thanks, Lindsay. Next question, Cindy, this one's probably for you. Where is the PHI located? Can you show where it is?
Well, we can't show because we don't have a
PHI log located. Sorry about that.
I was reading it. We can't show it because we don't have a system queued up to demo today, but it's basically a template that is stored in your EHR, and you go in and you log the request, and then some of these automatically go back to it. I've also seen groups that have customized it and moved into other places. So once again, it would be dependent on your system, but we can certainly get you some screenshots, and we'll send it out to everybody on this call of where it's standard,
And I can grab that too. I think standard, it's usually as a blue active text on the patient information bar up at the top, or you can access it through the patient demographics tab. But yes, it definitely can move around depending on your practice.
Yeah, and depending on the version and what, where you've got the option. So it's what we'll do is we'll do a screenshot of the standards and send it out to everybody. And then you'll just have to check to make sure it's located there. If you're not familiar with it, it's probably there because you probably didn't know it was there and you likely haven't moved it. Although it could be, again, not knowing the audience, it could have been moved. So we'll send you the screenshots, but understand that is the standard. That is the standard where they're located, not necessarily the same for everybody.
Okay, next question. What is the impact for practices that utilize third-party solutions for ROI? Cindy?
Okay, so ROI typically from my perspective means return on investment. So I would need to know more about the third-party application you're referring to and what it was replacing. It seems to me that if access is being granted and it's an application, and Lindsay, you feel free to jump in on this as well. If it's an application that is, providing access and requesting access, and you've accomplished it, even if it's a third party and not NextGen, it would be included. because you're providing the information they've had. But without more information, I don't know that I can answer that with any really great deal of confidence.
I think looking at that, obviously, if a third party is handling any of your release of information for you, I think it would just be sitting down, having that conversation with them, making sure that that company is aware of obviously this CURES Act legislation, making sure that they have documents and policies in place, and that they're, you know, as well prepared for this change and are in compliance with information blocking with this rule. So I think it's, if you have, again, that third party solution, again, if their job or specialty is release of information, they should absolutely be aware of this. I think it's just making sure that you have the documentation on file for yourself of policies and procedures that they have in place, and then your policies and procedures with that company to make sure that they are complying with, you know, this timely right of access, essentially.
Absolutely, and I agree with you completely, and thank you for jumping in. I don't want to answer definitively without knowing the applications we're referring to. I'm just always very, very cautious about that. But Lindsay's correct. Absolutely, if you can do this, it's basically up to the third party to provide that information. I'm saying it badly, and that was where I use the term return on investment, because that's a different thing. But Lindsay's absolutely correct. But I want you to make sure that you have the documentation in place.
Okay, thanks, ladies. Next question. And again, if you do have to leave, we will be sending out a link to the recording within the next week. So we're just going to still go through them all and answer them, and we won't feel bad if you jump off. Next question. Do you happen to have a policy template that we could use as a guide to establish our specific policies?
We do not have a policy template in place. We tend to shy away from any kind of policy template. We just have recommendations. We can work with you, obviously. I mentioned that healthcare industry advisor role to advise on policy and what we've seen, you know, included in other clients and other kind of industry standards that we've seen come out, you know, maybe even MGMA with some ideas. But we tend to stay away from templates just because also I know ONC, OIG, CMS are not fans of those templates either. So we definitely have some must-have, you know, kind of criteria in there, but it also really depends on your practice, you know, to truly make it unique. Because again, this whole information blocking rule, everything is going to be considered on a case-by-case basis. It's going to be very unique to your practice. We need to shy away from this one size fits all, check the box here to meet this. It's truly going to be a very kind of unique rule and system that they're going to have in place for this. So short answer, we do not.
Yeah, and absolutely, to expand on that, we do have worked with groups from in our consulting packages to do this, but we would want to have your compliance department involved, and if there's any legal ramifications, we would want your legal team involved as well. This is really important stuff, and there is no one size that fits all.
Okay, thank you. Next one. So if the patient access API is installed in our environment, from an IT perspective, there is nothing further that we need to do. Installing 6.2021.1 on 4/19/21 will meet the ONC certification requirement, correct?
So I'm going to jump in on this one right away. Again, I apologize. To get away from this mentality of, okay, I've got the API installed and I'm upgraded, I'm all set, I'm in compliance. That is not the idea behind it. There's so many other things that could affect your practice. You know, it's if you give vaccines, are you connected to the immunization registry? You know, are your interfaces, you know, up to date and ready to go? What did you have a compliance patch that needed to be installed that was available? There's so much more to it. I would hate to just pare it down to those two things. Those two things are very important components of this, absolutely, and you'd be on the right track with starting with those two, but it does include so much more than that, both the technical side and obviously, you know, looking at the policy and procedure side and training side as well.
Right, and I want to jump in, going back to some of the slides that Carly had. Pay attention to those slides about reaching with NextGen. I'm working with a client literally today on an application they purchased that indicated there was, you know, that all they needed was to have the API installed. It won't work, and NextGen's not supporting it. So you really want to follow those. As Lindsay said, you can't just, there's a lot of technical aspects to it. That's the start, but it's certainly not the end, and it's going to depend on what you're, you know, many of the things that you're trying to do, the applications, the API. So take a look at the slides, you know, revisit the slides that Carly went through regarding, you know, the process of working with NextGen. Anything to add, Lindsay or Carly?
Nope, that's good.
Okay, then moving on. Existing options like Care Quality or Share don't provide access to all the US CDI elements, do they? Is there a provider-to-provider solution that does?
So I can grab this one. I would refer back to the slide with our table on it that shows, based on your version, what USCDI options are available through NextGen. As long as they're listed there, they are available to make sure that you can transmit or share or access those elements that would be needed. You might have to get creative, of how the patient or the other practice is requesting that data from you. Again, if they're requesting that data from you and they would like it through NextGen Share through a direct message, you can send everything you can that way, and then you can go back and let them know, hey, the XYZ can't be included in that. I can send it to you a different way. So again, I would refer back to that chart that shows your version and what USCDI elements are available via NextGen as of right now, and then what's coming in the future. And as long as it's marked under that, it should be available. It'll just be focusing on that manner, the format that it's provided to.
Great, thank you, Lindsay. In another webinar on the topic, the presenter said that waiting until the provider saw lab results to release them to the portal would be problematic under the rule. Is this your understanding?
Yes, it is. So I don't know if this was asked before or after our slide on the lab results, but this was a big FAQ that was released from ONC recently. Any sort of blanket delay of EHI data, focusing specifically on lab results, I think is the most controversial topic right now, is that yes, if there is some sort of blanket delay for lab results being released, this could be considered information blocking. So we had some steps in our webinar that went over, can you describe why you're doing this? Can you prove that there is any harm involved to the patient? And if that would be preventing harm, not just a blanket statement that it would prevent harm to all patients, but on a case-by-case basis, why you're preventing harm for each one of those patients. So I think we are going to see more and more that any delay of lab results being sent out or released or made available is going to start disappearing.
Great, thank you for going over that again. If a patient opts out and doesn't want data shared, how do you stop it from going out through care quality?
So I can just speak to quickly, not maybe the care quality technical side of things, but keep in mind what we're looking at with this law, right? Your patient opts out. They don't want their data shared. You're not going to have an interoperability issue on your hands with that patient specifically. If that patient's requesting data and you don't want it sent out that way, as long as your patient and your other practices are happy, you're not going to get into any disagreement. Everyone's satisfied. There shouldn't be an issue with information blocking. Now, if a practice is requesting information on that patient and they don't want their data sent out, that's a different story. That's something, again, on a case-by-case basis. I think in ONC eyes and HHS's eyes, the patient's always correct. On the technical side of how we actually stop it from going out, Cindy, are you aware with that kind of?
I don't believe in care quality. And again, this goes back to some of the groups that I've used it, and I'm just reading the question. Trying to read the question in more detail. I don't believe that you can selectively say, depending on like going back to the lab results, if there's some portion of the care quality data sharing that you don't want to go, I don't think you can stop one aspect of it. It's an interesting question. I know that you've got to opt in or opt out and some of the different changes there, but I don't believe that you can just, and that's how I'm interpreting your question, is that you can't just selectively pick parts that won't go.
Okay, thanks. Next question. Where the patient is a minor and to avoid breaching the patient's confidentiality and trust with our provider, will the preventing harm exception cover us for any actions that interfere with a parent or legal representative's access, exchange, or use of the minor's record?
I can grab that one. So no, unless you're reasonably, for some reason believe a certain action that interferes with, specifically a parent's requested access or use of that minor's EHI, will actually reduce the risk or, at least substantial harm to that patient or another person. This preventing harm exception is not designed to cover that practice. The privacy exception, however, which is one we didn't talk about, but was listed on the screen as well, actually contains a sub-exception that covers practices respecting an individual's request not to share information subject to certain conditions. That also may be helpful, again, for that care quality question going back to. There are some other things hidden in these other exceptions that your practice could qualify for. Just due to timing, we didn't go over all of them, but there are 5 other ones that could have some subsections in here that would cover some of the instances we're seeing come through in the question panel.
Okay, great. Thank you, Lindsay. Next question. With care quality, if a request for information is not fulfilled for whatever reason, i.e. patient not found, duplicate, or patient opted out, we do not have a way of knowing that there was a request for information in order to satisfy that in some other method. Is that information blocking? This could be an enormous volume of requests that we are not aware of even coming through. Perhaps this is a question for NextGen that we need transparency to requests that we're not satisfied.
So I can hop into this one. I mean, yes, if the requests are coming in and you're not answering them, that is information blocking. You know, just because you're not aware of them, I do understand that, and I understand. You know, again, I think it's going to be such on a case-by-case basis. It's hard to say, but yes, kind of black and white answer would be, I believe you would need to be aware of these requests, and you do need to answer these, and we need to find out a way then to. And like you said, maybe this is a question for NextGen to find out a way to see those requests that aren't being fulfilled that are still out there. Because with that, with someone whose request was not answered, they could then go to ONC or HHS and say, you know, we sent this request over, here's proof of it. We have not gotten an answer.
Thank you, Lindsay. Next question. Does this apply for requests from insurance companies and attorney medical record requests?
I can grab that one. Yes, so that's kind of one of the non-traditional formats of requests that we're not used to. Health insurers in particular, the information blocking rule does not apply to health insurers. However, if the health insurer requests information from your practice, the information blocking rule applies to you. So basically, health insurers get all the benefits with none of the responsibility. They don't have to comply with the rule, but they do get request information from you and are expected to get a reply.
Great, thank you, Lindsay. Does health information blocking apply to health insurers?
Oh, that's the one we just did, I believe.
Just phrased slightly differently, but
yes.
We'll consider it done. Did you discuss the requirement about entering provider direct trust addresses on NPPES database?
We did not, but yes, that's a great point to bring up. As of last year, late in 2020, there was a deadline. It did actually get pushed back, so you still have some time. And there weren't really any penalties associated with it. But CMS had issued a final rule for all providers to update on the NPES database their direct address. In an effort for obviously, you know, to have full access directory-wise for providers, direct addresses to, you know, use NextGen Share or any other type of HIE to send that information to. So that is still in place. You do need to log into each provider's NPES account and add their direct address to that to be in compliance or update it if it's in there already. And that deadline was pushed back. I need to double check the new deadline, but I believe it was, Carly, do you have that by any chance? I believe it might have been the 1st.
I don't have it right now, Lindsay, sorry.
Okay, no problem. Let me go ahead and I can reach back out to you personally just to look at that. I just know it was previously, I believe October of 2020, and I believe they pushed it out just a few months due to COVID with their kind of mass delays here. So I can double check on the definite deadline for you.
Okay, and it looks like this might be our last question here. Would it be considered information blocking if a patient asks for part of their record that we have not captured as a practice, so thus we can't provide it?
I can grab that one. So, you know, medical groups they're only required to report the data elements that they've captured. So again, you know, it's not going to be considered information blocking if for some reason, you know, you're an ophthalmology practice and the patient's smoking status wasn't captured there. So it's not made available to the requester. Does that make sense? You know, you're only responsible for the data that you actually capture to share.
Okay, great. Well, it looks like we made it through all the questions. So thank you everybody who stuck in with us. And we hope that we answered all your questions. And if we didn't, again, you see Lindsay's and Carly's information up on the screen. Feel free to reach out to them directly. You can also reply back to, yeah.
do have an update for everyone. I wanted to make sure just before everyone got off, the deadline was extended. It was originally June 30th, 2020, and they just extended to the end of the year. So everyone should have updated their NPES profiles already. So please do for your providers.
Perfect. Thank you for that. So again, in summary, if you have questions, let us know. We're here to answer them. You can reply back to my email that I'll be sending with a link to the slides and recording, or any of the emails that you receive from me, or the newsletters, or any of the ways you can get a hold of us. We're happy to help, so don't hesitate to ask. And thank you all for joining us, and we appreciate it.
Great, thank
Thank you,
you.
everybody. Bye-bye.